Number 83, the people of the state of New York versus Phillip Wright. Good afternoon, counsel.
Good afternoon, Your Honors. If I could request 1 minute for rebuttal, please.
You may.
Thank you. Good afternoon, Your Honors. May it please the Court. Mark W. Vorking of Appellate Advocates for Appellate Phillip Wright. Your Honors, the trial court's denial of a for-cause challenge for a juror whose statements showed a clear tendency to credit police testimony was error.
Before you get to details of the error, as you've described it in your brief and in response to any questions you may hear from us, I just want to clarify something in this transcript. It's appendix pages, beginning on page 92. I'm interested in knowing whether or not these responses by what appears to be a female prospective juror regarding having family who are police officers is the same prospective juror, or is this a different prospective juror? Unfortunately, the transcript I see does not have prospective jurors numbered.
This is A92, Your Honor?
A92, yes,
92,
correct.
where it's blacked out.
Correct.
I think that both parties would agree that that's a different juror.
It's a different
This is that's not SB who's at issue.
That's what I assumed, but I wanted to confirm.
So the juror that we're talking about actually begins at page 93 of the record, where she says, or he says, we are all human and we make mistakes.
Yes, Your Honor, that's SB.
The juror that we're talking about stops at page 94, line 22, or?
I believe that the final colloquy, yes, the shore on 94.
Okay, that's the last thing that
Yes,
we're
Your
talking
Honor,
about.
just to
Okay.
clarify.
Just to clarify that,
Yes, Your Honor.
then the prospective juror who says no on page 95 is someone else.
Is someone else, exactly. So after the colloquy regarding police testimony, the question is put to the veneer as a whole, and another juror responds to that.
Thank you.
So originally there were 3 jurors being talked about, but now really we're down to this one, is that right?
Yes, Your Honor.
And that's at 93 and 94.
Yes, Your Honor.
Thank you.
SB, who we identify
Right,
in the
right.
brief. So SB's remarks, Your Honor, as Your Honors have pointed out on 93 and 94, at a minimum, evince clear bias in favor of police testimony.
Counsel, you started by saying that the juror expressed a clear tendency to credit police.
Yes, Your Honor.
Didn't she say that she doesn't automatically believe everything she hears?
She does not. She says she does not automatically credit testimony, and this is a position that I think the people have brought up
Is there
repeatedly.
a difference?
There is a difference.
What is that
Because
difference?
she then, counsel immediately asks a follow-up question, which is, do you lean towards that conclusion? And coupled with the question immediately prior to that, which is, so if a police officer comes here and tells you something, are you already giving them, because they are police officers, so therefore they are probably telling the truth? She says automatically no. I don't automatically believe things. Do you lean towards that conclusion, i.e., do you lean towards believing that police officers are probably telling the truth? And she says, sure.
Could that be interpreted as an expression of someone's confidence in the system?
I don't believe so, Your Honor, but I think even if her viewpoint is that officers, because of their duty to protect, she believes they have a responsibility to do right. She expects them to do this. This is the sort of the questions immediately prior to this point. She's clearly showing on this record that she treats police officers different than average citizens. She's asked that question directly.
Can't you read what's at the bottom of page 93, where admittedly the end is sort of cut off of what she was going to say or did say, as saying, well, you know, I know that police officers are humans and they make mistakes, and if they make a mistake, they probably want to, and the missing words are something like cover it up or make an excuse for it or something like that?
I think that's possible, Your Honor.
So this may exhibit a bias or may not exhibit a bias. It's ambiguous.
I think that, with respect, I don't believe it's ambiguous. I think that these remarks should make it likely that she would treat police officers different than other witnesses, and that's the threshold
Yeah,
for a
the standard
for-cause.
is not clear. I know you've started out with its clear bias, but that's not the standard.
That is not the
threshold
standard,
is
Your Honor.
lower.
It's much lower. It's a likelihood, so a likely that they would be unable to render an impartial verdict. And once that threshold is reached, the juror must be excused unless the trial court conducts a follow-up inquiry and is able to elicit an unequivocal assurance of impartiality. So our
Well,
position...
just so we're clear, and I know this didn't happen here, it doesn't necessarily have to be the trial court. It could be one of the attorneys who's trying to rehabilitate that prospective juror.
That's true. In a
Okay, I
hypothetical...
just want to be clear, because you said the trial court has to do it.
Well, I think the reason why I say that, Your Honor, is because this court has repeatedly stated, it's stated in Johnson, it's stated in Harris, it's stated in Nicholas, that a trial court, when the trial court fails to conduct a follow-up inquiry, where there are remarks suggesting a possibility that the attorney, that the prospective juror is biased, that itself is reversible error, because it's incumbent on the trial court to clarify what could be perceived to be ambiguous remarks suggesting a possibility of
But in
bias.
those cases, just to follow up on Judge Feynman's point and question, in those cases, because you don't have some other, because the law, as we look at the totality of this colloquy, we look at what the questions are, as you were pointing out, different questions, and so it could be, as it wasn't in those, that didn't happen, excuse me, in those cases, that along the line, something else is said based on inquiries from the prosecution or another counsel, that rehabilitates or clarifies or makes clear that these are unequivocal assurances.
Precisely, Your Honor.
Absent that, your
Absent
argument
that.
is that then the judge, our case law is that the judge has to ensure that those unequivocal assurances are on the record.
Precisely, Your Honor. Absent that, absent some sort of follow-up, be it by the judge, be it by a defense counsel, be it by the prosecutor, the juror must be excused unless, of course, the follow-up occurs and you get an unequivocal assurance of impartiality. And this court's case law is absolutely clear in that regard. And
So let me ask you this. The judge here, when he denies the for-cause challenge, says all she's articulated is the hope, that we should all hope that police are honest. If, let's take for one moment, your argument is that's not what she said, because that's what I remember your brief being. But let's say that there had been, in this colloquy, a statement from her, I hope that's what they do. Is that still leaving serious doubt, which is the language we've also used in these cases, about her partiality or ability to be impartial?
I think so, Your Honor. I think if she said, I hope, and she said these other things as well, I think that, again, it would still be incumbent on the court or someone else.
Well, why is that? Why is that not, as we've said in other cases, every juror comes with their life experience and particular predispositions, and they might say things like, I hope, I'll try, and so forth. And as you say, in the context, you're trying to ensure that this juror will indeed give these unequivocal assurances that they are going to be driven not by their bias or that they can overcome their bias. So if she just says, I hope, doesn't that still leave you with a problem? If the judge indeed, in his recollection of what she had said, was correct, that she had merely said, I hope?
I think if the judge was correct in the judge's recollection that she said, I hope, and again, she did not say, I hope, on this record, I think that might be a closer question as to whether or not a follow-up inquiry was required. This, of course, that is not this case. That's not what the juror said. And I think, the court, not only does it not conduct a follow-up inquiry, but with respect to the trial court, I think inaccurately characterizes what occurs and then cuts off discussion. So I
Did
think...
anyone suggest that they go back and look at the record to see what she actually said?
I think trial counsel pointed out to the court that she said, I give the benefit of the doubt to the police.
No, but there seemed to be this discussion about what people remembered, and isn't there a simple way to find out what she actually said in the moment?
I think there could have been, Your Honor, but I don't think that this court's case requires the defense counsel to prompt the court to do so. I think, again, this court has been very clear that at the end of the day, it's the court's responsibility to conduct the follow-up inquiry to verify the juror's impartiality.
Thank you, counsel.
Could I briefly address the Apprendi issue, if I might?
You have, I'll give you a little extra time in your rebuttal.
Thank you, Your Honor.
You're welcome. Counsel?
May it please the court, good afternoon, Your Honors. Jean Joyce for respondent. This juror had a very nuanced answer, a set of answers. She acknowledged that police officers could lie, can lie, that they are humans, just like everyone else. She expected police officers to do the right thing. That is not saying that she expected them to tell the truth more than anyone else.
No, you're right about that part of it, but again, our case laws, you have to look at this in context and everything that's said. And I want you to respond to your adversary's point that when she's asked, so if a police officer comes here and tells you something, are you already giving them, they are police officers, so therefore you're probably telling the truth. She responds automatically, I don't believe that I hear I don't believe what I hear all the time. Do you lean towards it? Sure. Why isn't that different from the language that you were first referring to?
That language is fine. She is asked, she says,
It's fine to say that if a police officer comes here and tells you something, you are already giving them the benefit of the doubt that
That
they are
was not the-
probably telling the truth. You lean towards that?
that was not the question that was asked.
I read the question that's asked. So if a
Defense
police
coun-
officer comes here and tells you something, are you already giving them, they are police officers, so therefore they are probably telling the truth?
And then the juror says, automatically, I don't believe what
know,
I
but
hear all the time.
I understand. You're missing the rest of it. I want you to respond to your adversary's point that you have to read the rest of it. When the
Correct.
follow-up is, do you lean towards that?
Right.
Or it?
Correct. And what the juror is responding to is, do you lean toward believing what you hear? Which is what she had just said. Sure, I believe, I lean toward believing what I hear.
All right, I
She
feel
broadened
it
the answer.
difficult to interpret it the way you suggest based on the rest of this. Does anyone, if I may, does anyone agree with her, because he is a police officer and he is testifying, you lean more towards them? She doesn't react to that. She doesn't say, that's not what I said, or no. I asked this at the beginning, is page 95, the answer after this and the colloquy after this from a different prospective juror? I've been told no. That prospective juror says no, immediately says, I don't
Right, he
measure
mischaracterizes
police
her
officers
answer.
differently.
Right, defense counsel then mischaracterizes her answer. Does anyone agree with her?
But
because
she
he's a
doesn't
police
say
officer?
anything. She's not making it clear that that's a mischaracterization. That's not what she means.
Every time she's asked a question in this colloquy, she broadens the answer beyond just police officers. She says, let me ask you something. There's an interesting point, because they are police officers. Are you giving them more credit than you would the average citizen? She doesn't
Let
say.
me ask you this. If you can't agree as to what this question and answers back and forth with this juror mean, did not the judge have some sort of duty to clarify and
This-
bring the juror in?
The standard
Or,
is this.
Or interrupt right in the middle and clarify?
The standard is this. It is not that if the juror says something ambiguous, that the judge must jump in and fix the question by defense counsel, which was somewhat convoluted. The standard is the juror must exhibit a state of mind likely to preclude the juror from rendering an impartial verdict. There is a huge difference between bias and ambiguity. And if you look at the entirety of the record, which you should with deference to the trial court, the entirety of the record indicates a juror that automatically would not believe what she heard all the time, refused to say directly, yes, I would credit police officers more than anyone else. When she was asked that directly, she did not answer the question.
But
The standard.
But she says she leans towards it. Again, even going with your suggestion that every answer is now broader, it's now responding not to this category of questioning, which is about police officers, but just in her general frame of mind. You're saying that she said, I don't automatically believe everything I hear, but I lean towards believing what I
Right,
hear,
she
even
said-
though the whole conversation has been about whether or not police officers, because they are police officers, are people that you might be more likely to believe.
She never agreed with counsel's statements. He asked it
You-
3
you
or
made
4
a-
times.
You made an interesting point, I thought, the difference between bias and ambiguity. Is that what's required here, though? It seems to me that what's required is that there has to be a manifestation of doubt, serious doubt as to impartiality, and either bias or ambiguity, either one, and I agree with you, they aren't the same things, I think you're right about that, but either one of those things can lead you to doubt about impartiality, which is not the same thing as either one of those. You see the distinction I'm drawing?
Yes, there is a distinction. However, counsel's questions, I believe, led to some of the confusion. But if
Well,
you're
that's their
looking
job.
for-
His job is to make things
Exactly.
confusing as
But-
possible for them.
But if you're looking for an assurance of impartiality, it's there by the juror herself. Automatically, I don't believe what I hear all the time.
But I do some of the time, and I lean towards it.
Well-
Aren't we still back to this question of whether or not it meets this lower threshold, not of certainty of bias, but of just some serious doubt, a likelihood?
What we're back to is giving deference to the trial court who saw her body language, saw the
Well,
interplay.
wouldn't this be an entirely different case if you're sitting there in the judge and jury selection, you're looking and you go, Miss, I need to know, can you be fair and impartial to both sides in this? And you judge the police officer's testimony the same way you judge any other witnesses. We wouldn't be here now, would we?
Right, but that's a rule of practice, it's not a rule of law. And sure, there are many times when if just one more question were
Well,
asked.
God help us, maybe it should be, but you see what I'm saying?
Sure,
Yeah, okay.
yes, I grant you that, absolutely. But this judge was there, saw what she said.
But
and-
in the cases, have we done that? I thought we look at the actual cold record colloquy and decide from there. Have we said we defer specifically to
said
the
that-
judge?
You have said that there is deference to the trial judge who has the ability to...
What case have we say that? That we decide whether or not there's a serious risk, but in that context, we defer to the judge's observations. Where do we say that?
You most recently in Warrington, which you decided in December of last year, just said repeatedly that the standard is an abuse of discretion standard. And you've
In that
also
case, did we
said-
do anything other than read what the cold record said? And
There are
make a decision
cases-
based on that?
There are cases which state that the trial judge has the ability to view the juror, and cited in my brief, I can't find the page right now, view the juror, watch the interplay, look at the body language, and so deference is owed. It's,
Even in the face of language that at a minimum is ambiguous? You defer even when assume for one moment that one would read these responses, this colloquy, and agree, well, there's ambiguity there, I'm just not sure. Are you saying then the law is, from this court, that we tip in favor
If-
of deferring to the judge?
If there's some ambiguity under 27021B, whether a juror should be challenged for cause, it's up to the party who is making the challenge to say something, meet his burden.
Other than completely changing, and I know the red light's on, but is there anything you want to say about the Prindle issue other than, or the Apprendi issue, other than we just decided this in Prindle?
The court just decided Prindle, and I urge you to apply Prindle in this case.
Okay.
Thank you,
Thank
counsel.
you.
Counsel?
Thank you,
Counsel,
Your
do we
Honors.
get in trouble if a lawyer defense counsel during voir dire asks a prospective juror, we're going to have police testimony in this case, do you expect that police officers uphold their sworn duty and honor their oath of office?
If defense counsel were to ask that to a prospective juror?
Well, yeah.
Well, I'm not sure exactly what that question would mean to a prospective juror. That would depend on their interpretation of what the officer's
Well,
sworn
if
duty
the
is.
juror answered, yes, I expect police officers do, when they swear their oath of office, that they do, swear to do their job honorably, which impliedly includes testifying truthfully, right, arguably?
Arguably.
Did we get in trouble there?
I think so, Your Honor. I think that would raise a doubt as to the prospective juror's ability to treat police officers just like any other witness, which is what we require.
So if there's a follow-up question and said, would you expect the same of any other witness, even though there may not be a sworn duty, they're swearing under oath, and the prospective juror said, yes, I feel the same way toward any other witness, then end of story, right? Not a problem.
Probably, Your Honor. Under that hypothetical, I think probably. I think, again, of course, that's not what happened here. And I think that the colloquy here was more focused on, I think, officers versus civilians in terms of their ability to be truthful, not necessarily to uphold their oath. I mean, obviously, the prospective juror gets into officers, her view of what their duties are, their duty to do right. But again, it comes back to, I think, Judge Fahey's remarks about doubt. And I think that this record is full of doubt at a minimum. Our position is, of course, that it evinces clear bias, but doubt at a minimum. I just want to address deference really quickly. I think this court's decision from Warrington last term is a classic example of what the trial court is supposed to do. There was doubt. The court conducted the follow-up inquiry, and was able to elicit an unequivocal assurance. This court said that in that context, you can defer to the trial court once it's done that follow-up inquiry as to the record as a whole. Of course, no follow-up inquiry was done here. Just briefly as to the Apprendi point, Your Honors, this case is not controlled by Prindle. Prindle did not raise the Hurst or the DeCamp arguments that we raised in our brief.
But Hearst is actually cited in Prindle, isn't it?
Hearst is cited in Prindle, Your Honor, of course. But the specific holding in Hearst had to do with the Florida Supreme Court's interpretation and its conclusion that its statute did not violate Ring. And so our argument is focused on that issue. DeCamp is not addressed in Prindle. And then the as-applied challenge, because we raised both.
But we've already said that the PFO is not unconstitutional under considering the determination of Ring. So Ring did not lead this court to believe that the PFO should, our interpretation of the PFO should be revisited. And as you say, Hearst is just another application to a different jurisdiction of the rule of Ring.
Well, actually, our position is that Hearst is not simply a reinterpretation of Ring, that Hearst dealt with a particular scenario where the Florida Supreme Court had construed its death penalty statute to get around an Apprendi problem. And the Supreme Court said that the Florida Supreme Court needed to focus on the statutory language at issue, the practical effect of the statute. And our position is that under that reading, Hearst, which is an expansion of Ring, that the PFO statute remains unconstitutional, particularly as applied to Mr. Wright, in which during the PFO hearing, the trial court made a particular factual finding regarding whether or not he attempted to use the firearm at issue, a finding that the jury never found, a finding that the jury arguably rejected in acquitting him of the more serious counts, and that involved a count, the possession with intent to use, that the court itself chose not to submit. The people concede, of course, that the trial court made this factual finding during sentencing, and so we would argue that at a minimum, and as applied to Mr. Wright, the PFO statute is unconstitutional under Apprendi.
Thank you, counsel.
Thank you, Your Honors.